chance to meet many of you who are new this fall in terms of graduate students, but I'm going to introduce Dr. Walden today. Professor Ruth Walden, and she said not to say too many nice things, but I'll try to keep it down. Professor Ruth Walden is a School of Journalism and Mass Communications James Howard and Hallie McLean Parker Distinguished Professor. She has served or is serving, among others, as chairwoman of the Graduate Admissions Committee, member of the UNC Chapel Hill's Graduate School Administrative Board, and its Academic Policy Committee in the UNC Systems Graduate Council. Until 2007, Dr. Walden was the School of Journalism and Mass Communications Associate Dean for Graduate Studies. She is the author of Insult Laws and Insult to Press Freedom, a worldwide study of insult laws that was commissioned by the World Press Freedom Committee. In October of 2000, she was a member of the U.S. delegation to the annual Human Rights Implementation Meeting of the Organization for Security and Cooperation in Europe in Warsaw, Poland, where she delivered the U.S. Statement on Freedom of Expression. She is also the author of Mass Communication Law North Carolina, several book chapters and articles in Journalism and Mass Communication Monographs, Journalism and Mass Communication Quarterly, Journalism Educator, and Hastings Communications and Entertainment Law Journal. She is the author of the chapter on access to courts in one of the most widely used undergraduate media law texts, Communications and the Law, as well as the libel chapter in the North Carolina Media Law Handbook. Her research and teaching interests are mass communication law, First Amendment theory, and mass media ethics. She frequently chairs media law dissertations and theses, and her students at the undergraduate and graduate, master's, and doctoral levels have consistently met with great success, both as students and, perhaps more importantly, professionally, once they graduate here from the school. For instance, recent graduate Dr. Kathy Roberts-Ford now serves on the faculty at the University of Minnesota, and her dissertation won the prestigious Nafziger White Award given by AEJMC and was just published by the University of Massachusetts Press. Dr. Walden was her doctoral chair and advisor, of course. I could go on and on about Dr. Walden, but let me turn things over to her now. She's going to present to you a study, a piece of research that she recently presented in the Law and Policy Division at the AEJMC convention this past August in Chicago. So please welcome Dr. Walden.
Okay, for almost everybody in this room, the part of the introduction that Professor Huff just didn't do is I'm the one who gave you that test on Tuesday that was way too long that you couldn't possibly finish in 75 minutes, right? That should have been part of the introduction, I think. Okay. This paper, that I'm going to present, this research, is actually research that I did last year with Derrigan Silver, who many of you know. Many of you met him when you were here interviewing, or some of you who are second and third years were here, studying at the same time. And Derrigan is one of my PhD advisees. He's right now teaching at the University of Denver in Colorado, finishing up his dissertation, I hope, as we speak. And he actually did the presentation. I think some of you were there at the Chicago presentation, and he actually did the presentation, so this is the first time that I'm going to be the one speaking about it. Let me tell you where this idea came from, because the idea for this paper was very old. Back in 1993, I read an opinion in a libel case that occurred in North Carolina, and the attorney for the defendant in this libel case was Hugh Stevens, who, again, some of you may know. Hugh Stevens was at the time the attorney for the North Carolina Press Association, a very active, well-known media lawyer in the state, and he was the attorney for the defendant. And I read this case, and let me tell you what the facts of it were, because it's pretty interesting. The lawsuit, the name of it was Sleem versus Yale University. A man by the name of Dimitri Sleem, who lived in North Carolina at the time, I don't know if he still does, was a 1975 graduate of Yale University. And like a lot of universities, Yale did reunions for its graduates. And as part of the reunions, it would often put together books of information about the people from the various classes that were having reunions. Well, in preparation for the 1990 reunion, among other classes that they targeted for this book was the 1975 class that Dimitri Sleem had graduated. So questionnaires were sent out to all the 1975 graduates asking them, just what they were doing and all kinds of things. And there was a section on the questionnaire that was personal information. Well, the questionnaire with Dimitri Sleem's name on it was returned to the Office of Alumni Relations at Yale. And under the personal statement portion, it said this: I have come to terms with my homosexuality and the reality of AIDS in my life. I am at peace. So they went ahead, Yale went ahead, published the book, put out the alumni directory with Sleem in it. And imagine Mr. Sleem's surprise when he opens the book and found this, since he had never responded to this question. He hadn't answered it. This wasn't anything he wrote. Someone else had written his name on a questionnaire, sent it in, and it was published as is. So he brought a libel suit, defamation suit against Yale University. And all these people who just took my test Tuesday know that why this case ended up in a federal district court in North Carolina, because of course Yale, is a citizen of a different state. Sleem was living in North Carolina. The case was argued in the Middle District of North Carolina in Greensboro. And the whole thing is really interesting about what the court said about it, but there was one particular paragraph that at the time, and this is back in the early 90s, really caught my attention. The court was talking about a recent case, a relatively recent case, Dun Bradstreet versus Greenmoss Builders. And what the court said was the implication of Dun Bradstreet is that in private individual, non-public concern cases, a plaintiff is no longer constitutionally required to prove fault. This is implied because the state interest in allowing presumed fault is of similar weight as the state interest in presumed damages, and I'll talk about this later. But thus, Dun Bradstreet allows the states to choose whether to allow presumed damages and impose liability without fault in cases involving private person plaintiffs and non-public issues. Now, when I read that, that was a big surprise to me, the court saying that no fault was okay as long as it was a private person and a non-public issue. And I'll tell you why in a minute. But it was that particular case that kind of made me think about it. And, I sort of sat on it for obviously a really long time, because it's 2007 when we're writing this paper. But Darrigan ran across this, I don't know, maybe about a year and a half, 2 years ago, when he was preparing to teach his undergraduate law class. And he came to me and he said, "You'll never guess what the court said in Sleem versus Yale University." And I said, "Yeah, well," and I said, "I've been thinking about that for 10 years. And so this is what prompted us to work on this paper. It was kind of this little serendipitous thing of, it took him prompting me 10 years later to sort of say, yeah, I've always wanted to do a paper on that. Okay, well, what were we looking at? We really had two research questions, the first one encompassing actually the second one. We were interested in finding out how lower federal courts and state appellate courts have interpreted the various U.S. Supreme Court defamation decisions to determine when or whether and how constitutional protections even apply in a case involving a private plaintiff and a private, non-public type issue. And again, I'll get back and talk about those terms in a second. The second question is really just a little bit narrower restatement of the first. The question is, are lower courts, like this one in North Carolina, reading the Dun Bradstreet versus Greenmoss Builders case narrowly to affect only what was covered in that case, and it was presumed and punitive damages, or are they reading it broadly to cover all aspects of cases that involve private figures? So, what's the problem? Where did this come from? Well, here's the background that you need to understand it. Beginning in 1964 in New York Times versus Sullivan, the Supreme Court began applying constitutional restrictions in libel cases. And the court started out by saying public officials have to prove fault, and they have to prove a very high level of fault known as actual malice, which means knowledge of falsity or reckless disregard for the truth, in order to win their libel cases. This was a really radical departure from the common law, the earlier law that applied in libel cases. Because earlier, before Sullivan in libel, it was a tort of strict liability. In other words, no fault. The defendant was responsible whether he or she showed any fault whatsoever. It was a total no fault, strict liability kind of offense. So when the Supreme Court first imposed this fault requirement in libel in 1964, that was pretty radical, but they did it not on the basis of the subject matter of the article, but on the basis of the plaintiff. The Sullivan case involved an elected public official suing the New York Times. And so the court said that person is going to have to prove either that the New York Times knew the material was false or published it with reckless disregard for the truth. So that was sort of the start of applying the First Amendment to libel law. A few years later, in 1967, the court extended constitutional requirements in libel to public figures in two cases. One was called Butts versus Walker. One was called Butts versus Curtis Publishing Company, and the other was called Walker versus Associated Press. But still, it was on the basis of the status of the plaintiff. Public officials and now public figures had to prove constitutional fault to win their libel cases. A few years, 1971, a few years after Butts, there was a little blip in the radar, so to speak, or a little blip in the straight line the court had been traveling. And in a case called Rosenblum versus NonMedia, the court was very badly split, but the three-member plurality, the group that garnered the most votes, said that the actual malice rule was going to apply whenever a matter of public concern was discussed, that it didn't matter if the plaintiff was public or private. What mattered was the subject being talked about in the news article. And in this case, the plaintiff was clearly private, but the subject matter of the discussion had to do with an aspect of law enforcement. And the court said, or three members of the court said, well, that subject matter is sufficient to trigger this actual malice requirement. 3 years later, in Gertz versus Robert Welch Incorporated, the court backs off on this and says, no, we're going to stick with the status of the plaintiff in determining fault. And so in Gertz versus Welch, the Supreme Court says public officials, public figures must prove actual malice. Private people must prove at least negligence to win their libel suits. But then again, it's focusing on who's suing, not the subject matter of the report, but who's suing. Also in Gertz, the court says, but for punitive damages, which are where the big money is in libel cases, you know, the $5 million awards, or presumed damages, and that's just a category where the plaintiff doesn't have to prove that he suffered harm, the court will presume it. Everybody, public or private, has to prove actual malice. Okay? So the rules are, at this point in time, in 1974, you know, if not simple, at least relatively straightforward. Public people prove actual malice to win their lawsuits. Private people prove negligence. Everybody proves actual malice for presumed and punitive damages. Well, a few years later, again, in Dun Bradstreet versus Greenmoss Builders, which was 1985. Well, it's actually more than a few years, so a decade later. A case comes to the Supreme Court that involves clearly a private plaintiff, and the court said a matter of private concern. Dun Bradstreet's a credit reporting agency. Greenmoss Builders was what it sounded like, a contracting company, a building company. Dun Bradstreet sent out a false credit report on Greenmoss Builders to some subscribers. The credit report said that Greenmoss Builders had declared bankruptcy. That wasn't true. A principal of the company had declared bankruptcy, but the company itself was fine. The company was solvent, it was fine. Well, as a result of this erroneous credit report, and I mean, think about it, if it happened to you, you know, if somebody sent out a credit report on you that said you declared bankruptcy, you'd be pretty upset about that. Well, you know, Greenmoss Builders is pretty upset too, and they asked for a correction. Okay, Dun Bradstreet sent out a correction. But Greenmoss also said, we want to know to whom you sent these reports. And Dun Bradstreet refused to reveal the clients, who had paid for these reports. So shortly after that, Greenmoss Builders filed suit for libel in Vermont, in Vermont state courts. Well, the Vermont state courts were trying to figure out, okay, how do we apply all these U.S. Supreme Court holdings to this case? And what the Vermont Supreme Court ended up saying was, none of these constitutional restrictions apply in this case because it's not a media defendant being sued. So the Vermont Supreme Court says Greenmoss Builders, they don't have to prove actual malice to get their presumed and putative damages because they're not a media, because Dun Bradstreet's not a media entity. Well, Dun Bradstreet appeals to the U.S. Supreme Court, and the U.S. Supreme Court agrees that Greenmoss Builders doesn't have to prove actual malice to get presumed and putative damages, but not for the reason that the Vermont court said. The Vermont court had said, remember, they're not media, therefore they don't have to prove the actual malice. The Supreme Court ignored that media, non-media question completely and said, well, Greenmoss Builders doesn't have to prove actual malice to get punitive and presumed damages because the subject of the report was not a matter of public concern. The Supreme Court went back and said, what we really meant in Gertz, we didn't say it, but what we really meant was that if the person suing is private and the issue is of public concern, then that person will have to prove actual malice to get presumed and punitive damages. But if the person suing is private and the issue is of private concern, the Constitution is not interested, doesn't have any impact on that kind of lawsuit. Now that's not what they said in Gertz, but that's what, 11 years later they tried to convince us they said in Gertz. Well, this was followed up by two other cases that are mentioned up in here. In Philadelphia newspaper versus Heps, that involved who has to prove falsity in a libel suit. And again, the Supreme Court made the distinction on the basis of the subject matter of the report, not the plaintiff's status, but the subject matter of the report, and said if the subject of the report is a matter of public concern, then the plaintiff must prove falsity. And then a few years later, in Milkovich versus Lorraine Journal Company, that case involved an issue of application of constitutional protection for opinion. And the court also kept using this matter of public concern language. So what we had by 1990 in Milkovich was one line of cases that says what matters for the Constitution is the plaintiff's status, public or private. And then we had another line of cases that said, well, in some issues what matters is the subject of the report. Is it public or is it private? So this is, I'm trying to go through this real quick because I know a lot of you haven't covered any libel in class and I don't want you to be too lost, but it's pretty muddy. It's pretty muddy by this time what the standards are. And then adding to the confusion is something I mentioned that the Vermont court did. Throughout all kinds of Supreme Court opinions dealing with libel, there are frequent mentions of media, non-media distinctions. Now the Supreme Court never directly said different standards are going to apply to media and non-media cases. But for example, in the Heps case that I just mentioned, the one involving falsity, Justice O'Connor wrote that opinion. And she specifically said that the court was not considering what standards would apply in a case involving a non-media defendant. In the Milkovich case, Chief Justice Rehnquist wrote that opinion, and he said, the court is reserving judgment at this time as to cases involving non-media defendants. So the Supreme Court all this time has been hinting, well, maybe there'll be some differences depending on the defendant, if it's media or non-media. And that, of course, is what the Vermont Supreme Court took and ran with and said, it's not a media defendant, therefore the constitutional protections don't apply. So, you know, we've got subject matter, plaintiff status, and then maybe defendant status counting too. So it's a pretty muddy area at this point in time. As I mentioned, when I was describing Dun and Bradstreet, what the Supreme Court, what a majority of the Supreme Court did, was to try to sort of ex post facto rewrite Gertz. Justice Powell wrote the plurality opinion in the Dun and Bradstreet case, and he said that, well, what Gertz showed us was that speech on private matters was of reduced constitutional value. Chief Justice Berger in concurrence said, Gertz in its entirety does not apply at all in private cases. Another Justice White, Byron Wright, who concurred, said it must be that the Gertz requirement of some kind of fault on the part of defendant is also inapplicable in these cases. In other words, these guys are saying maybe nothing from Gertz applies in private cases. Maybe even negligence isn't required. And then Justice Brennan, who wrote the dissent, kind of, you know, subtly and gently accused his colleagues of lying. In professing allegiance to Gertz, the plurality opinion protests too much. In other words, what Brennan's saying is, you guys are trying to convince yourselves and us that this naturally flows out of Gertz. It doesn't, okay? You protest too much. Well, that's kind of the background on it, and I'm sorry it has to be sort of so convoluted, but the point is, you know, it is convoluted. Otherwise, it wouldn't be interesting. These cases generated a lot of scholarly criticism. A lot of people after Dun and Bradstreet wrote and said, you know, there is simply no way that Dun and Bradstreet can be reconciled with Gertz. Others attacked the idea that a court could be in the position, or should be in the position, of determining what is a matter of public concern. Hard enough for them to determine who's a public figure, but to do subject matter evaluations, a lot of scholars, a lot of critics said they shouldn't be doing that. And of course, then there was the question of how far does Dun and Bradstreet go? Again, the basic question is, Dun and Bradstreet, the court said, if it's a private plaintiff and a matter of private concern, then the Constitution does not require that individual to prove actual malice to win presumed and punitive damages. But what the court didn't answer was, in a private plaintiff, private issue case, does the Constitution place any limitations whatsoever on what states can do? That was what they didn't answer. And that's what was left unclear. And Rodney Smola, who's a leading expert in libel and privacy law, wrote shortly after the Dun and Bradstreet, the precise scope of Dun and Bradstreet remains unclear. It will take years for its implications to evolve fully. Well, we figured 20 years had passed, so that's the years that were needed for its implications to evolve fully. And it seemed like a good time to take a look at the cases that had been decided since Dun and Bradstreet. So what Durgan and I did was Westlaw searches using a whole strings of terms that are noted in the footnote of the paper. We used a whole variety of Westlaw searches to identify all federal and state cases that addressed the impact of Dun and Bradstreet and or discussed what should be the fault standard in a private plaintiff, private issue defamation case. Now, I want to make clear, we didn't just restrict our study to private cases, because very often in cases involving public figures or public officials or public issues, the courts discussed, even some of them set out tables and charts of what, you know, of standards apply in what kind of case. So all the cases we looked at, some of them, a lot of them were private issue, private plaintiff, but a lot of them were other types of cases in which the courts in dicta discussed what types of standards apply in other kinds of cases. We identified cases from 8 U.S. courts of appeals, 14 U.S. district courts, appellate courts in 22 states, the District of Columbia, and the Northern Mariana Islands, which I did not know had a Supreme Court until we were working on this. That's a U.S. possession, and so that court fits there. Yeah, so I learned something, a little side thing about the Northern Mariana Islands. After reading all these cases, and there were 40-some cases in total, we came up with 5 categories that they fell into. In other words, there was no single answer here. There were the courts that said Dun and Bradstreet signaled a return to the common law in private cases. In other words, there were courts that said what the Supreme Court did in Dun and Bradstreet was say the Constitution imposes no limitations whatsoever when a private individual sues over a matter of private concern. And, oh, I should have had these all come out at once. Those were the 4 federal courts, 4 state appellate courts are the ones that we found that fit into this category. You'll see only 1 U.S. Court of Appeals. The others were district courts. But these were some pretty interesting opinions. There was one, for example, that involved Donald Trump, and we used that one as our intro because it was so funny. But Donald Trump got involved in a dispute with a financial advisor over whether his casino, the Taj Mahal in Atlantic City, was going to be a success or not. And I threw this in just for Rhonda, and she's not here. I was going to talk about a casino. Anyway, so they got in this big public dispute over it with Donald Trump dissing this guy, his name was Rotman, in Philadelphia Inquirer, New York Post, Barron's, Fortune, Vanity Fair. He called him a very unprofessional guy, a man with very little talent, not a good man. He just, was, because the guy said Taj Mahal was a mistake, it wasn't going to make any money. Well, when Rotman sued Trump and the case got to court, the court decided that Rotman was a private person. That was no surprise, because of course Rotman, we'd never heard of him before. And that this dispute between Trump and Rotman was essentially a private matter. That it was not a matter of public concern, that it was a personal financial dispute between the two of them. And so the court said, in this case, both Rotman and Trump had thought that constitutional protection for opinion would be the issue in the case, whether this was protected under the First Amendment as opinion. The court said constitutional protection for opinion doesn't apply. Private cases, the Constitution has nothing to say about it. Our state's common law is what's going to apply to this case. So, I mean, that was a pretty remarkable ruling. So these were some very interesting cases. One quote that, for each of these, I just put up a quote that kind of encapsulates this group of cases. And this one came out of the Fifth Circuit. And this was one of the most influential of the cases we found. We believe that 5 justices of the Dun and Bradstreet Court supported common law standards for private cases. We therefore conclude that the Constitution imposes no minimum standard of fault in private libel cases. And that means states are free to do whatever they want with no constitutional limitations. The next category we found were, I'm not very good at animating slides. Sorry. The next one we found was a category where a whole bunch of courts went, we really aren't too sure. It seems like it might be, it sort of looks like the Supreme Court implied, that kind of language, but they didn't come out as certainly as the other group. And this is, again, a good quote summarizing it. It is unclear whether the First Amendment prohibits states from imposing strict liability in a defamation case brought by a private plaintiff concerning statements that implicate a matter of private concern. And that was the First Circuit. And this was, by the way, Lewinsky versus Walmart was the name of this case, not the Lewinsky, not the Monica. But a lot of these private cases result from Now, this was an allegation of shoplifting, a very public allegation of shoplifting. You know, this woman was, you know, grabbed in the store and accused loudly of having been stealing from the store. And, you know, friends were around and everything else. And so a lot of these cases, you know, aren't media cases. I mean, some are, like the Trump one involved a lot of media publication, but a lot of these are private disputes. A lot are also, divorce leads to defamation a lot of times, I've noticed. People get really nasty, and so some of these have been divorce-based suits where spouses told a lot of others what they thought of their ex-spouse. So, another group, but a very small group, only two, we can only find 2 courts that fit in this category, were courts that explicitly and directly said, we recognize that others may be interpreting Dun and Bradstreet broadly, but we're not doing so. Dun and Bradstreet does only one thing only. It eliminated the actual malice requirement for presumed and punitive damages, and that's all it did. And California Supreme Court was one example, very explicit. Dun and Bradstreet affects only the showing required for presumed and punitive damages. Philadelphia newspapers only affects the showing required for falsity. You know, we're not going any further. We're not interpreting these any more broadly. But it's interesting that we could only find 2 that did that. What maybe is just as interesting is how many lower courts totally ignored the existence of Dun and Bradstreet. That's by far the largest group. And what these courts did when they had to deal with these questions, like they had to decide what they were going to do in a private case, they cited Gertz and only Gertz. You know, they just pretended that Dun and Bradstreet never happened. Or they cited only state precedents. So they would have a lot of state law that had been decided between Gertz and Dun and Bradstreet, because Gertz was 74, Dun and Bradstreet was, what was it, 85? Yeah, 85. So they had a lot of state decisions in that time period. They'd only say the state decisions. So they just totally, you know, pretended that Dun and Bradstreet had never happened. Or maybe they weren't pretending, maybe they didn't know, you know, but, you know, they just, you know, ignored it as if it wasn't there. And then there were a few courts that outright rejected it, said, we recognize the Supreme Court said that actual malice does not apply or have to apply in private cases when you're deciding on presumed and punitive damages. We reject that approach, and we've decided that under our state law, it will be required. You know, because states can always have a higher standard. They can be more protective of freedom of expression. They can't be less protective than the First Amendment, but they can be more protective. And, oops, I left one off. So, that's it. So here's probably the best example of a court ignoring Dun and Bradstreet, or one of the good examples. Court cited only Gertz, and I pulled this one especially because it's, you know, relatively recent. It's the 9th Circuit. You know, it's U.S. Court of Appeals. So presumably, you know, those guys know the law. Totally ignored Dun and Bradstreet, cited only Gertz, and said a private person who is allegedly defamed concerning a matter that is not of public concern need only prove, in addition to the requirements set out by the local jurisdiction, that the defamation was due to the negligence of the defendant. You know, went on, just like I said, never, you know, pretending that there was nothing in after Gertz. I wonder why these are backwards. Like I said, I'm not very good at animating. This was the New Mexico Supreme Court that had the most explicit language and said, okay, we know what the Supreme Court did. We know that the Supreme Court recently distinguished Gertz, declared that states you know, don't have to require actual malice. We declined to follow Dun and Bradstreet on that issue. You know, we know what they said. We're just not going to do it. We're going to make our state law more protective. And then the final category was identity of the defendant and what we call other approaches. Identity of the defendant is what I was talking about before. Even though the Supreme Court has never said expressly that media, non-media makes a difference in constitutional standards, Some lower courts are still doing that. Other approaches applies to sort of a potpourri of things where sometimes you just couldn't figure out what the courts were talking about, period. Sometimes it was, there was one case in which one court said that Dun and Bradstreet increased constitutional protections in libel cases. And you were like, huh? You know, they said you don't have to prove fault to win. That's not an increase in so sometimes they were just like these bizarre things that we couldn't figure out what else to do with them because they didn't really make much sense. And those were the ones that fell into that category. An example of the identity of the defendant came out of the Seventh Circuit, where the court said there's still doubt whether the Constitution applies the same standards to media and private defendants. You know, they can't figure it out because the Supreme Court's never been clear on this matter. So, you know, we had kind of entered into this hoping that we were going to find like two categories. You know, one category of cases in which courts were doing what the North Carolina court did in Sleem, and they were saying, okay, you know, Constitution doesn't apply at all, where states are free to do whatever they want. And then we were hoping there'd be another category where very narrowly applying Dun and Bradstreet, where courts said explicitly all Dun and Bradstreet affects is the punitive and the presumed damages. But that's not what we found. I mean, we found all this uncertainty, all this confusion. You know, if you add together the categories of the number of courts that either ignored Dun and Bradstreet or indicated they were uncertain and unclear, that was by far the vast majority. So what are solutions? Well, you know, in our humble opinion, the best solution would be for the Supreme Court to reverse Dun and Bradstreet and return to the real Gertz rule, where private people prove negligence to win their lawsuits, public people prove actual malice. Everybody proves actual malice, though a high level of fault to get presumed and punitive damages. That's very unlikely to happen, especially with the current makeup of the U.S. Supreme Court. It's very unlikely that this conservative court would back off what was a decision that was some cutting back on free expression rights. Another alternative solution is just clarification. For the U.S. Supreme Court to say, okay, you know, all we meant in Dun and Bradstreet was that actual malice is not required for presumed and punitive damages. But in private plaintiff, private issue lawsuits, plaintiffs still have to prove at least negligence to win. In other words, stopping courts from going back to no fault, you know, where you can lose a libel suit even if what you did was, you know, purely accidental through no fault of your own. We figure that's somewhat unlikely because they've had plenty of opportunities to do that. There have been plenty of petitions for certiorari to the Supreme Court in cases in which this could have been cleared up, and they've denied them all. So, you know, we're not real hopeful that this is a solution. So the alternative, and it's a very interesting alternative that we talked about for a really long time, is that states return to actual malice or common law malice themselves. In other words, doing what New Mexico's court did. You know, the New Mexico Supreme Court said, we will not follow what the U.S. Supreme Court did. Instead, our state rule is going to be that in order to collect punitive presumed damages, an individual must prove actual malice or at least what is known as common law malice. And common law malice was defined as including either actual malice, knowledge of falsity or reckless disregard for the truth, or an intent to do harm, ill will, you know, that kind of malice. That, you know, the problem with a solution like this, leaving it to the states, is of course you run the risk of having, if not 50 different standards, maybe 20, maybe 15, you know, maybe 30. And it's also funny because, you know, back in the days when I was starting to learn constitutional law and media law, The states were the ones that were seen as more of the danger to free expression rights. And it was the federal courts and the Supreme Court that we looked to for protecting First Amendment rights. I mean, it was the states that in the Sullivan case, imposed was a $500,000 verdict? I think it was $500,000. I think it was $500,000 verdict on the New York Times for an ad that didn't even name Sullivan, but he said defamed him. And it took the Supreme Court sort of to recognize First Amendment rights and set it right. So it's kind of an odd thing, for somebody like I, who studied in the 70s and when we were looking to the Supreme Court for the protection of civil liberties, to now say, well, maybe we have to return to the states. But at least, some of the states are indicating that they are more concerned with keeping standards and protecting freedom of expression. By the way, another reason, I meant to say this at the outset, but I forgot, another reason that Durgan and I were really interested in this topic is because the internet is making private suits really a major category. You've all seen the various websites where you can go on and complain about your plumber, and what is the name of that one where you post comments about
Angie's List.
Yeah, Angie's List, thank you very much. Yeah, where you say, don't hire this guy, he's terrible, or this is a terrific one. Well, these kinds of, the ability of individuals now to communicate widely and, internationally with people telling about, their encounter with a sales clerk at Macy's or, a plumber or whatever is generating a lot of these lawsuits because these are matters of private concern, but they're being widely published. And people are bringing lawsuits saying, hey, you defamed me, you hurt my business. So, we're expecting, that there will probably be a proliferation. Okay, I feel really sorry for these people who now are going to have to listen to me for another hour and 15 minutes after this. But any questions? I went kind of fast, huh? Yeah, Jane.
I may not have any idea what I'm talking about, but I was wondering.
That's okay, I don't either, so it's good.
This is fascinating, but I'm thinking about this. If it's being left to the states, then couldn't it still go back to the Supreme Court? Couldn't somebody still appeal to the Supreme Court and say, wait, the state doesn't want to use the Dun Bradstreet case, but I want to?
Well, but if the state had, as long as the state's rule is more protective of expression, then, the Supreme Court can't, well, taking a property, no, that wouldn't work. The Supreme Court can't I had to stop and think about an alternative. The Supreme Court can't step in and say, you can't protect more than the Constitution does. Now, the Supreme Court can step in and say you can't protect less than the Constitution does. Does that make sense? It's like, isn't it, am I right, Michael? Is it Oregon that eliminated their obscenity laws?
No, I'm not sure about that. The example I thought of was, for instance, our state constitution. The North Carolina Constitution has an open courts provision that includes civil courts, but the Supreme Court has never said there's a First Amendment right of access to civil court proceedings, but we have one for a state court system in North Carolina. So that's going to be more protection for First Amendment rights, and isn't that?
Yeah. Well, and actually, the other one I thought about now, California has interpreted its state constitution to protect free speech rights on some private property. It was, in this particular case, it was a shopping center. And California said, we protect some speech rights on private property. The Supreme Court has said not. The Supreme Court has said the First Amendment doesn't apply to, like a shopping center saying, hey, we don't want you here talking. And a state can be more protective, it just can't be less protective. So that's why New Mexico can say, we're going to protect more than the Supreme. We decline to follow that. We don't think that's good enough protection for free speech. And yeah, like I said, it's an odd thing because that's not the way we used to think of it. We used to think of going to the federal court system to protect our rights. Yeah, Kathy.
Pretend I'm Dean Smith, because this is what he would say.
Which Dean Smith?
The smart one that I'm not very far. But Dean is teaching my class. That's why he's not here.
Oh,
notion of always looking to the Supreme Court to protect our rights has caused us to spend 35 years, wasting our time gnashing about First Amendment-based reports privilege. That, and that it was something that came out after New York Times v. Sullivan, which was we thought to be such a wonderful decision that we just thought, okay, every time we have a problem now, we'll just go to the Supreme Court and say, what about the First Amendment? And the Supreme Court would fix it. And they didn't fix it in Brandenburg.
Right.
But we continue to struggle with that for 35 years about, well, maybe it's in the First Amendment. It ought to be, there's only like 1 million people who written the same article that says the First Amendment should protect you from having to reveal your confidential sources.
Yeah.
And, so his conclusion is, we should just, we gotta get over it. And particularly with the court we have now, and look for other places for our protection. He wants, of course, Congress isn't helping us that much either. But, to look at Congress and state legislatures and state courts to give us the protection that we used to just assume. And I'm from that school too.
Yeah.
That, that's what you always did. You went to the Supreme Court.
Oh yeah, because this is all part and parcel of it wasn't just the First Amendment either. It was, all the criminal defendant rights. This was the era of, Miranda, all of these, increasing protections for civil liberties under the U.S. Constitution. And that's not happening anymore. Yeah, Michael.
Just a real quick follow-up, and then I had a point. But I think another really good example of that is access, that the Supreme Court's never really given any kind of constitutional right of access to government records, government meetings, and other government-controlled information outside of a limited right to attend criminal trials. But nonetheless, access advocates have pressed on with, every state has open records and open meetings laws. There's a federal open records and meetings law. Many state constitutions now have open records and meetings provisions. And I think, people have kind of given up on the Supreme Court ever giving some First Amendment right of access to proceedings, even though some lower courts have done that. But I think that's another good example of that kind of phenomenon. But the other point the point to me that all of this is very interesting. That media, non-media point to me is very interesting. I think it comes up in a number of issues. There's a case I used in my undergraduate class, and it's a Fourth Circuit Court of Appeals, federal court applying state law in North Carolina. And the only issue on appeal was the only issue and the only type of damages the plaintiffs could recover was presumed damages in a libel case. And it was an actual malice. Was there enough evidence below to allow the case even to go forward on actual malice? And the appeals court said we don't have to worry. There was some debate about whether the plaintiff was a public official or not a public official, and the trial court and appeals court said we're not even going to deal with that issue because the only damages being sought are presumed damages, so she has to prove actual malice anyway. But we look at this case, and it's a nonprofit organization that issued a press release, and then we go through the facts about what they did before releasing this press release, and then I asked the class, what do you think? Is that actual malice? And we've just looked at all the press cases, and they almost 90% say, oh gosh, yes, that's just as bad as anything that any of these press defendants have done. And the undercurrent was because it was a nonprofit, because it's not a media defendant, they're kind of held to a different standard, not kind of professional standard. So what sort of looks like actual malice, you'd think, was considered as a matter of law not to be actual malice. That is interesting to me. I don't know how you really study that because they don't. It's not mentioned. That non-media, professional, non-professional distinction is not even mentioned. But it sure is an undercurrent.
Maybe you study that kind of like that Watt Hopkins study about different cases. You look to see what was considered to be negligent in cases. You study what's considered to be actual malice to make a difference, whether it's a newspaper or a public relations practitioner.
Or who?
Or a blogger. It'd be a very interesting thing to see if they do think about sort of different standards of behavior that they need to.
But that has implications for like a non-professional blogger. Is that level of actual malice can be low? I
mean, it makes sense to have, or it makes some degree of sense to have different, what's the word I'm looking for, empirical definitions of negligence, depending on who it is, because negligence, one definition is a failure to follow professional accepted standards. So, what is the profession? But for actual malice, it doesn't make any sense because knowledge of falsity, or reckless disregard for the truth. And reckless
This was a
disregard.
reckless disregard case.
But at serious doubts, high degree of awareness of probable
Right.
falsity, purposeful avoidance of the truth.
Right.
I mean, none of those things seem to be something that would differ depending upon, you know, who the defendant is.
Yeah, I agree. And
Yeah.
this was things like calling to check with a source and then not getting a response back, but then issuing the press release anyway. Isn't that just as bad as
That's-
not calling?
And that's, yeah. Well, you know, like I said, if you go, I mean, we thought about another possible follow-up on this study, but I think Durgan's got to write his dissertation first. But, you know, a follow-up on this would be delving into that media, non-media, because we were really amazed at how confused the lower courts are over whether that makes a difference. And, you know, usually the cases that we look at are media cases. And so you don't realize it, but when you start getting into private cases, you get a lot more non-media defendants. You get a lot more individual defendants, and boy, the lower courts are confused.
Well, do they ever talk about the line of cases that says that the First Amendment's the same for everybody and it doesn't matter if it's the media or an individual?
No, they pull the
Because they've been
quotes.
so adamant about that it's all the same. Then when they start making these,
Yeah, but you know, the Supreme Court's been adamant about it when it's been access. So like when you're talking about, you know, Richmond newspapers versus Virginia access to courts, and it's, you know, public and the press have equal rights. But those libel cases, just go through Kurtz and Heps, again, carefully. You know, you're not looking for the holding, which is typically what we're doing, but you look at that language they use, and repeatedly they'll talk about, you know, when a so-and-so a broadcaster sues the press, sues the media, and, you know, are they using that descriptive or are they using that normative, you know? I mean, do they mean that standard applies here because it's the press, or is it just their description of what's going on? It would.
I mean, calling on just kind of a conjecture on your part, did you get a sense that the language that was used when they were referring to the media versus the non-media was critical, maybe to their decision, and did they use it in a way where they were kind of justifying their decision, or was it just kind of random dicta?
I think they were using it as a rationale for the decision because you know, in so many of these cases, especially starting with Sullivan, where they're talking about, you know, the watchdog function of the press and necessary for democracy, and, you know, all the sort of, you know, lofty values, you know, many of those relate much more to media coverage than to none. And so I think as in the justification of some of those early decisions where they were advancing free expression rights, the language was used very purposely, not to indicate though that private or non-media defendants wouldn't have the protection, but more as a rationale, you know, or justifying. In the later decisions, in Heps, Milkovich, and Dun Bradstreet, you know, it wasn't decided on the basis of it. But, you know, in Heps, Sandra O'Connor, you know, we were talking about Sandra O'Connor before, she very specifically says, and, you know, when a media defendant is involved, we're not deciding non-media here. You know, I don't know what that means. You know, I don't know if that was her hinting that she would not give the same level of protection to non-media. Was that something she had to put in to get enough people to sign on to make a majority? You know, I don't know. I mean, it's just like that same line in, was that the Hazelwood case where the court said in a footnote, you know, we're not discussing whether this applies to colleges? Is that where that was? Anybody?
Yes.
I think so, yeah. It's that same kind of thing, you know, where, what do you mean by that? Are you hinting it might apply? You know, I don't really know.
I don't know if you did this, but did you look at any of the literature about judicial line drawing between high value and low value speech?
No.
To see if there ever was a word. I just read something like last week, but I'll give it to you.
Okay.
Just a general sort of piece about this. That this is basically how the court works. They have high value speech, which is everything except what's low value. The other, you know,
Yeah, the other.
and the categories and how that's sort of in the big picture how they've done it. But I'm sure they didn't talk about this, but that might be another sort of interesting
You're
way
right.
to look at this.
Yeah, 'cause that's-
there is literature about that, and it kind of fits in there more broadly than just in the, sort of the libel.
You know, but what's really, to me, I guess, what's really disturbing about this is that, you know, when you're talking about the high value and the low value speech, as long as you're not talking about unprotected, as long as you're not talking about obscenity or true threats or whatever, there's some protection. And what's bothersome about the way some of the lower courts, the first ones, the ones that said Constitution doesn't apply at all, is they're saying, you know, private plaintiff, private issue libel cases, no constitutional protection. It's totally unprotected by the Constitution's speech. And that's really troublesome, because that's putting that speech in the same category as obscenity, true threats, fighting words, you know. That's
That they still protect by the common law, right?
well, yeah, if the states choose to do
If the
it.
states choose.
If the states choose to do it, you know, I mean, the states could choose to protect obscenity too if they chose to do it. If anybody, you know, wanted to run on that on a ballot.
Not this year.
Yeah, but that, you know, I mean, that's really troublesome to me, because, you know, when you say private, I think that may diminish a little bit, you know, you don't recognize how important some of these cases. So, for example, one of the cases that we dealt with was one where a surgeon, well, back up, this is the hospital setting for this thing. You know, there was this one anesthesiologist, a couple of patients that, you know, he was working on died. Surgeon goes to the hospital administrator and the board and everything and says, you know, we gotta get rid of this guy, you know, he's a terrible anesthesiologist, he's killing patients, you know, I won't work with him anymore. I mean, this was really a serious issue, and so then the anesthesiologist brings a libel suit, or, and some of this was written and some of it was oral, against a doctor, and, you know, this is a private, it's ruled to be a private case, because it's all, you know, kind of internal. And so it's not trivial. It might be private, but it's not trivial. You know, that
Don't you think that's an issue of public concern, whether this guy is killing patients in the hospital?
but it wasn't big, you know, it wasn't deemed to be such by the court, and the way in which it was handled, it wasn't like it was a newspaper article about dangers of going into the hospital and not coming out again. It was an internal, you know, investigation sort of situation. And, you know, and whether the doctor was right or not, I don't know, but it's not trivial, and he should have some degree of protection under the Constitution if he's trying to keep his patients from getting
and
killed.
there's plenty of theory that suggests that all that private speech about private issues is very valuable
Well, that
to
was
citizens in our society and to broader society.
yeah, and that, I mean, that was the theory in Virginia, pharmacy, you know, that even though it's prices, you know, what Harris Teeter's selling grapes for this week is still of interest, you know, and is entitled to some constitutional protection. I mean, and that's another comparison. You know, why should a Harris Teeter food ad get constitutional protection and a doctor going to say, hey, I think this guy's killing my patients, doesn't? I mean, that doesn't, you know, that doesn't ring right. Yeah, Michael.
And also to follow up on that, you know, you get that blurry public controversy standard in the public figure analysis, and then that legitimate matter of significant public interest in the privacy cases like Florida Star, and that was blurry too, with the court kind of, well, yes, investigation of a crime is a legitimate matter of a significant matter of public interest. Is the alleged sexual assault victim's name, does that fit in with there? 5 justices saying, well, yeah, that's part of that. 4 justices saying, no, never. But that kind of blurriness about, that's that focus, I guess, on content.
Yeah, that's a content focus, which is, you know, problematic, you know, from the very beginning.
Deciding what these, you know, public controversy and all that stuff means.
Yeah.
Did you find this private business in any other kinds of cases like false light or leafleting cases?
We found it in false light, but we didn't put false light into the category, because false light, you know, is already kind of muddy because of the Time v. Hill, where the court said whenever the subject matter of the report is of public concern, the plaintiff has to prove has to prove actual malice in false light cases. And I did a piece on that. That was one of the things in comment a number of years back, where half the courts were applying, actual malice based on the status of the plaintiff, and half were based on the subject matter because the court had never clarified that one. But we just knocked those out of the running. Most of the cases, though, you know how often they are both false light and libel. Most of these weren't. Most of these were straightforward libel cases. There were very few where there was that add-on false light allegation put into them.
And I wonder if it's in any other kinds of like pure speech. Private people talking about private issues, leafleting or something.
Yeah.
I guess they don't usually leaflet about private issues, but they could.
Well,
If dead people in the hospital were a private issue, then I think.
Yeah, I mean, well, then there's my all-time favorite one where the couple in the middle of the divorce, the wife starts telling people about the husband having sex with the dog. Oh, I love that case. That was a gem.
That
You know,
is private.
that was private. You don't think
Don't
that
tell
was?
that story, that's private.
Oh, okay. I that one could go on Entertainment Tonight. I think that would be public, but. I don't know, they didn't get to that part, I don't know. But that was what she was telling everybody. Oh my gosh, she's taping this. Yeah. I forgot that Jessica was taping this thing, and here I am. So, you know, libel plaintiffs say the darndest things, you know. I know you guys, you're going, oh my God, now I gotta listen to more of this. Anyway, anybody else? Well, thanks for your attention, appreciate it.